While the term automatic license plate reader is a pretty self-explanatory one, how the case came to be is very important. 6 years ago, United States Postal Service worker Tamara Clayton was fatally shot on the I-57 highway. This unfortunate expressway shooting sparked a movement within the community, Illinois State Police, Illinois Department of Transportation, local police agencies, and the governor's office. On January 1st, 2020, Illinois enacted the Tamara Clayton Expressway Camera Act to fund the installation of approximately 300 cameras known as automatic license plate readers, or ALPRs, across Cook County expressways. 2 years later, Illinois passed a statute appropriating additional funds and extending the program to 20 other counties. To date, the Illinois State Police has installed 344 cameras in Cook County, 78 in St. Clair County, and 44 across 17 other counties. Now, as with so many cases, the road to hell is paved with good intentions. I feel for Ms. Clayton's family and recognize the desire to be safe. But does our desire to be safe trump our rights or the rights of others? On the other hand, does our right to privacy trump the rights of others to be safe? Maybe there's something in the details that can help us navigate this conundrum. The surveillance program works in 2 steps. Installed on the side of the road, ALPRs photograph or detect the license plates of vehicles driving by them. The system then uploads the photo to the Law Enforcement Archival Reporting Network, or LEARN database. This national database compiles and stores billions of license plate photos taken by ALPRs in Illinois and elsewhere. Okay, that sounds terrifying. Billions of license plate photos stored in a national database that can be used to track wherever you go. Unfortunately, it gets worse. Law enforcement agencies across the country flag, quote, hot plates of vehicles that are targets of investigation. For instance, if the car is reported stolen, is used as the getaway vehicle in a bank robbery, or has expired registration, license plate photos sit idle in the database until there is a, quote, hit, when the ALPR detects a hot plate. When police receive notification of the hit, they can enter the LEARN database to retrieve the license plate photo and associated metadata of when and where the photo was taken. This information allows police to see what cars passed by that area at the relevant time and to whom those vehicles are registered. Last month, ALPRs in Illinois recorded 200,161,762 detections and 5,747,483 hits. So all law enforcement needs for the system to start searching this database for plates is to flag them. Yes, there are plenty of reasons for law enforcement to legitimately search for a license plate, but there are plenty of legitimate reasons for them to search for anything. However, in this country, those searches must be reasonable. That usually means the government must get a warrant, but apparently not for searching the LEARN database. Under the Expressway Camera Act, an Illinois State Police officer may retrieve a license plate photo from the database to investigate any offenses involving vehicular hijacking, aggravated vehicular hijacking, terrorism, motor vehicle theft, or any forcible felony, including but not limited to offenses involving the use of a firearm. They may also retrieve a photo to detect expressway hazards and highway conditions and to facilitate highway safety and incident management. By statute, all images from the cameras shall be deleted from the LEARN database within 120 days unless the images are relevant to an ongoing investigation or pending criminal trial. Again, if law enforcement has probable cause to search the database, why not get a warrant? Probably because a warrant would limit the scope of law enforcement search to the data relevant to the case they were investigating. Plaintiffs in this case challenged the Expressway Camera Act and Illinois' warrantless use of ALPRs, claiming they violate the Fourth Amendment's protections against unreasonable searches and warrant requirements. They asked the court for a preliminary injunction, preventing the respondents from accessing ALPR data without a warrant. Defendants moved for dismissal due to a lack of jurisdiction.